Okay, on to more practical exam type issues. Uh, First of all, as I promised in the last video, we're going to talk about unemployment division versus Smith. But we also talked in the last video about there's a threshold question, what constitutes a free exercise claim to begin with, right? Under current law, a free exercise claim arises, as I said, not when the government's promoting religion, that's an Establishment Clause case, but when the government is interfering with somebody's religiosity, right? So either forcing them to do something that they don't want to do in terms of praying or religious practice, or more commonly, of course, stopping somebody, right, from doing something that they want to do as part of their religious practices or beliefs. That is a free exercise claim. Now you notice, just said the word belief, right? You don't have a free exercise claim unless you have a belief, a religious belief, right? A belief about religion. So about, right, God and the supernatural and God's role in the universe, right, or God or gods, or whatever one person's faith or belief might be. So that raises the question that we talked about a couple of videos ago, right? People can claim to believe anything. And I can challenge virtually any law, right, by coming up with some reason why, in my alleged belief system, I can't go along with that law. As I talked about in the last video, this is going to be really interesting if the court goes full on prophylactic free exercise, and I don't even have to go. Never mind, I don't have to go along with laws, right, that make me do something or make me abstain from something. I don't even have to go along with laws that make me feel offended. So, for religious, because of my alleged religious beliefs. So this, again, things are going to get interesting here in these religion cases. But the court has found a way to deal with, again, before we get into employment division versus Smith, right, the court has found a way to deal with this problem. And it's kind of a threshold issue in these free exercise cases. When somebody raises a free exercise claim, obviously because the Constitution applies to state actors, right, governmental actors, there's going to be some kind of governmental actor, right, who's the defendant, right, in one of these cases. And the challenger will be challenging the government. So when somebody raises a free exercise claim against the government, the lawyers for the government are allowed to argue that the religious beliefs, right, or that the person at issue who's raising the free exercise claim, the government is allowed to argue that that person does not sincerely believe what that person is claiming to believe, right? Put another way, although very similarly, the government, right, lawyers for the government are allowed to challenge the sincerity of somebody's religious belief. And again, that means I'm claiming that you don't actually believe what you say, like the Pastafarians, right, who claim to believe in the flying spaghetti monster. I could challenge in court whether the Pastafarians actually believe that, or whether they're just being whether they're just trying to make a point and they don't actually believe it. Now, why am I emphasizing that so much? Because you have to distinguish between that and something else that the government is not allowed to do, right? The government is allowed to challenge the sincerity of your belief. It is not allowed to challenge the reasonableness, right, of your belief, or whether your belief itself is true. The nature of faith, obviously, is what we call faith, right? Faith is the belief in largely supernatural and unprovable phenomena. And, you can see where the Supreme Court has been coming from on this, right? There's no way that we're going to subject religious beliefs, right, to some kind of test about whether the belief itself is reasonable, right? We can, let me back up again. I can challenge whether you believe it, right? But if you do believe it, I cannot challenge in court whether what you believe is, crazy, out there, unreasonable, nonsensical to me, right? Because look, I mean, everybody who has, especially people who have dogmatic religious beliefs, right, believes that everybody else's religious beliefs are unreasonable. So that's not going to fly. That's not going to work. Courts are not going to become the arbiters of what are reasonable religious beliefs. We're not putting We're not putting the virgin birth on trial, right? Just to pick one example of a common religious belief. We start there. Okay, so you have the general framework for free exercise. We've talked a little bit on a sort of a theoretical level of what exercise means, right? But it has to involve, a free exercise case has to involve, right, some profession of belief, right, that has been offended somehow. Government is allowed to challenge whether you believe it. Government is not allowed to challenge the reasonableness, right, of your belief or whether your belief is accurate. Okay. That brings us to the test. And again, the main case, right, that lays out the test is Unemployment Division versus Smith, authored by Justice Scalia. In that case, Justice Scalia took a view of free exercise that is very much, as I mentioned in the last video, right, and I'm going to put up some language here, right, from Justice Scalia's opinion there. Right, he lays out his view of free exercise, right, as again involving active religiosity, or right, laws that target religion, because it's religion, laws that overtly, right, on purpose target religious practices or require, right, either that you perform or abstain from those practices. And then Justice Scalia says this: the religious objectors in the present case, however, I'm looking at the second paragraph, seek to carry the meaning of prohibiting the free exercise of religion a large step further. They contend that their religious motivation for using peyote, so I'm sorry, I should have started there. This is a Native American religion, right, that under which adherents to the religion believe that smoking peyote, right, is a part. Well, they don't. Yeah, it is part of their sincerely held beliefs, right, that they should smoke peyote as part of their religious practices for spiritual purposes. There's a law that makes smoking peyote illegal, and the law is generally applicable. Okay, the law doesn't have any exceptions. It's like a couple of videos ago when I talked about the speed limit, right? There are no exceptions. There are no built-in hearings to decide who has to follow the speed limit and who doesn't have to follow the speed limit, right? It applies the same way to everybody. And this law that bans the use of peyote is the same way. It applies to everybody the same way. There are no built-in hearings to decide who can and who can't, right? There are no exceptions about who can and who can't. And so the question is, right, a law that does not target religion, it does not target religious beliefs, right, but that does stop some people from doing something, right, that they believe in their religion they should be doing, right, is that a legitimate free exercise claim? And of course, you know, Justice Scalia said the answer is no. So let's look back to what I was reading. They contend their religious motivation for using peyote places them beyond the reach of a criminal law that is not specifically directed at their religious practice and that is concededly constitutional as applied to those who use the drug for other reasons. They assert, in other words, that prohibiting the free exercise of religion includes requiring any individual to observe, here you go, generally applicable law that requires or forbids performance of an act that his religious belief forbids or requires. As a textual matter, we do not think the words must be given that meaning. So there you go. Okay, here's the general rule. And I'm probably making this more complicated than it has to be. If a law is generally applicable, meaning there are no exceptions and no built-in opportunities, right, for the government to target people on the basis of their religion, then the free exercise claim is over. Okay, that is how it works under Employment Division versus Smith. Now, we're going to talk in the next video, right, again about two different types of cases where you identify, right, laws that are not generally applicable, right? A generally applicable law is one that has no exceptions, no built-in individualized decision-making, right, that applies the same way to everybody. This is one of those laws. That means that in this case, right, the challengers lose, the government wins. As to the free exercise claim, there is no free exercise claim when you're challenging a law that does not target religion, right? Okay, now, if the law is not generally applicable, right, so you see your flow chart developing here, right, a law that is generally applicable, you're done. under the free exercise clause. A law that is not generally applicable, you apply strict scrutiny, and we'll look at that as well in the next video. So that's enough for this one. Once again, please stay well, and we'll be back to talk about free exercise one more time after this.